Connecting with my friends, love it. Connecting with some sketchy guy that needs remote access to my computer, really?
We hear you. That's why AARP created the Fraud Watch Network.
If you don't think this is right for me when you think AARP, then you don't know AARP.
Get our next session started here. My name is Justin Kozak. I am a researcher and policy analyst with the Center for Planning Excellence. Welcome to Annual New Case Law Update on Louisiana National Zoning Issues. We're going to be updating you on zoning and planning case law, highlighting both Louisiana and national examples and their implications. Before I introduce our speaker, we'd like to thank our sponsor, Jones Walker, and also to remind you that there's an hour's worth of credit for CLE, and if you don't see somebody else, you can just give me your forms at the end of the session. With that, it's my pleasure to introduce Christopher Tyson. He's the Newman Trowbridge Distinguished Associate Professor of Law at the LSU Law Center. He joined the Law Center faculty in 2010 as an assistant professor. He teaches and writes in the areas of property, real estate development, local government law, and urban land use and development. Professor Tyson earned his BA in architecture with honors from Howard University. He has a master's of public policy from the Harvard Kennedy School and a Juris Doctor from the Georgetown University Law Center. While at Georgetown, Professor Tyson served as articles editor of the Georgetown Journal of Gender and the Law and received the Dean's Certificate of Recognition of Special and Outstanding Service to the Law Center community. Prior to earning his law degree, Professor Tyson worked in management consulting and in the Washington, D.C. office of United States Senator Mary Landrieu. After earning his law degree, Professor Tyson worked as an associate in a real estate practice at the law firms Jones Walker here in Baton Rouge. He has been honored as one of the Baton Rouge Business Report's 2010 Top 40 Under 40, the National Bar Association's Top 40 Lawyers Under 40 for 2011, and the New Leaders Council 2011 Top 40 Under 40. He's also recipient of the National Bar Association and Impact's 2011 Excellence in Activism Award, and he was a 2015 Democratic candidate for Louisiana Secretary of State. Professor Tyson.
Good afternoon. I have the unfortunate privilege of following our governor, so I don't know if this will be as interesting or as captivating as Governor Edwards, but I do appreciate you sticking around for this presentation. I'm going to talk about new developments in land use and zoning law. I'm going to talk specifically, I'm going to talk specifically about a general overview of land use and zoning law. Most of this for the attorneys will be a refresher, or for those of you not as familiar, hopefully it'll provide some background to kind of ground our conversation going forward. I then want to focus a little bit on exactions following the recent 2013 Supreme Court case, Kuntz, which we will discuss in some detail. And then I'll talk about short-term rentals, which is an emerging area in zoning and land use law of controversy and litigation and regulation, specifically in New York and San Francisco, which kind of have the standout issues right now. So we'll talk a little bit about that. And then we'll have questions. And certainly if there are questions during this presentation, feel free to raise your hand and interrupt me, and I will recognize you and we can have a discussion. So zoning and land use has been with us longer than 100 years, but it was 100 years ago that New York City adopted the nation's first zoning ordinance. And following that, zoning ordinances began to proliferate around the country. And it was in 1926 that the Supreme Court took up the matter in the case of Euclid v. Ambler Realty. And in Euclid, the court effectively constitutionalized zoning, which allowed the village of Euclid in Ohio to pursue a use-based segregative district model to allocate public space for residential, commercial, and industrial uses. The scheme came to be known as Euclidean zoning, and Euclidean zoning is a term that continues to this day, that refers back to a system of use districts which segregate uses and define a number of relationships between those districts and constitute the state's ability through, the local government's ability through its police power to control its land uses within its borders out of concern for the public interest. And so since then, we've seen a rethinking of Euclidean zoning to bring into play more transect zoning, which is what we call our plan unit development ordinances, our traditional neighborhood development ordinances, and other ordinances which attempt to mix uses, relax stringent segregative requirements between districts and among districts, encourage more dense development. And this, as many of you know here, is an advance pushed by the planning community over the last few decades to modify Euclidean zoning to suit the emerging needs and tastes of contemporary society, particularly around environmental sustainability and walkability. The same forces that pushed for zoning also pushed for land use planning more broadly. This is the period of the 1920s, which is driven mostly by the progressive movement. Now, the progressive movement had its drawbacks, right? This progressive movement supported eugenics. The progressive movement was very much in favor of Jim Crow and racial segregation. But what the progressive movement did get right is to attempt to professionalize city services and bring some sort of logic and professionalization to planning. And so we see that growing in the early part of the 20th century, and as zoning regimes begin to proliferate around the country, we also see that we have planning through the Standard Planning Enabling Act of 1926 and other measures adopted within the states that pushed comprehensive planning as a way for communities to design their own futures, and this was a way to organize these public property rights, as I call them, the community's desire to limit what private owners can do in favor of the health, safety, welfare, and morals of the community. And so we see comprehensive master plans that come into play, and those call for the regulation of subdivision, street plans, plans for public facilities, building regulations, and so on and so forth. And now we see kind of a broadly accepted understanding of statewide planning and regional planning as a core function of local government. And so we can trace that evolution from the beginnings of zoning and planning. But there are legal implications of this, as we all understand. Land use and zoning regulations constitute substantive restrictions on property rights. They prioritize these public rights above private rights, and for many people that feels wrong to us, right? And we instinctively rebel against it because of how we culturally feel about private property rights. I can tell you, and those of you who practice in land use know that oftentimes you will encounter a client who has the impression that she has many more rights than she has, and goes through the planning and zoning process, deals with public bodies and other interests which impact what she can do with her property, and comes to discover frustratingly that there are significant constraints on what property owners can do with property. And so that is what we encounter in the zoning and land use realm. Courts have generally held that regulations are permissible so long as they are reasonable and not arbitrary, and that they bear some substantial relation to the public health, safety, comfort, morals, and general welfare of the community. These we call the police power, the local police power, the ability of local governments through powers devolved from states down to the local governments to control, to exercise their own self-determination, the course of their community through the development of the land within their borders and the development of a market for private property and the maintenance of property values. We all know in communities that protecting our property values is sacrosanct, that most Americans have the majority of their wealth in their home. And so there is a high degree of risk and consequentiality associated with land use and zoning regulations. But this issue of reasonableness and whether something is arbitrary or capricious, yes. Is obviously an ambiguously low bar. And so courts are routinely called to interpret that, and courts have interpreted reasonableness on a range of factors, including the needs of the municipality, the purpose of the restriction, the location size, physical characteristics of the land, the effect on property values. As you go around the states, you see courts, depending upon the strength of the overriding land use regime. Some states have comprehensive land use planning at the state level and therefore are very specific in statute as to what the limits of reasonableness are. Other states leave that to the common law. It just depends. And of course, we are concerned ultimately about spot zoning, that we have arbitrary distinctions being made between zones in a city that unfairly benefit or burden private parties in a way that deviates from a comprehensive plan or any conception of substantive and procedural due process, which are the cornerstones of how the court views the constitutionality of zoning schemes and other regulations that impinge private property rights. Again, this is a review for many of you, but it's important to highlight as we think about this and discuss some of the issues to come. I thought that it would be helpful. There isn't much groundbreaking, if anything at all, in recent case law regarding planning and zoning, but I thought I'd pull at least 3 cases that I thought would illustrate some of the contemporary issues we find. And so I'll highlight those briefly. Here we have a Shreveport case from last year where a plaintiff sought to build a store on a property that was already zoned. They argued that they had the right to build this store that was a Dollar General store as a matter of right. This was a use by right case. And the court, however, found that the city's ability to, in its discretion, approve the site plan, and the city disapproved the site plan, was permissible and did not allow the entity to build the store, even though they had zoning and the use by right. And so here just affirms the broad discretion, particularly in Louisiana, that courts give, the broad deference that courts give to planning bodies and zoning review boards to, even through the site plan process, deny applications for new buildings. And here we had issues with regards to the facade of the building, the layout of the site, landscaping issues. There was a Family Dollar store across the street. There was significant neighborhood opposition. In spite of that, the owner thought that because it was used by right, they had the ability to move forward. But through the site planning process, the city was able to deny that moving forward, and the court affirmed that in this case. Do we have a question? Yes.
Not only the site plan was denied, not that they couldn't build a store
Exactly. So they could come back with a revised store plan or another concept and build that. Exactly. So this particular plan by the developers who were doing this in conjunction with Dollar General was that particular plan was disapproved. You're right. Thank you. Any other questions? The next case is a New Orleans case. Here we have a store that was operating as a legal non-conforming use. It was forced to shut down after Hurricane Isaac. And following the hurricane, the store applied for a restoration permit. A non-conforming use in New Orleans is allowed 6 months. To be vacant before they lose the right to operate that non-conforming use. Going outside of that requires a restoration permit. They applied for that. They were granted that and later revoked. The Board of Zoning Adjustments there found that the damage to the store actually was not caused by the hurricane, but rather continued neglect. And so the neglect actually was the basis for the inability to operate the store and to be vacant. The owners, the Board of Zoning Adjustments alleged, were using that as pretext to secure the restoration permit and continue the non-conforming use. And so the Board of Zoning Adjustments revoked that permit. The courts upheld that. And here we're just understanding the limits of operating non-conforming uses, and it's kind of getting into notions of vested rights, although the court here did a fact-based inquiry into the basis for the restoration permit and rejected it on that ground, on those grounds. And then finally, we have a Plaquemines Parish case where there was an agreement to build a shopping center on a 35-acre tract of land. The parish then adopted an ordinance which stopped the issuance of permits. The plaintiffs here argued that the ordinance stopping the issuance of permits was unconstitutionally vague, violated constitutional rights. The court here clarified that applying for a permit does not constitute a vested right. I think this was a weak argument, but I thought it was interesting that the appellate courts clarified that issue here. And here we're affirming, once again, that zoning is a legislative function. And courts give broad deference to governing bodies to amend, supplement, modify, change, repeal existing zoning ordinances as they see fit. And the bar of reasonableness and whether or not a decision is arbitrary and capricious is, many argue, a low standard, but it is one that courts have determined is necessary to account for the range of local situations and nuanced facts that could impact or lead a zoning entity, a board or a commission or city council to make a certain decision. So I pulled those three cases, nothing else groundbreaking that I found in a review of case law, but I did want to pepper this with some local cases, so we have some examples there that basically affirm what we know about zoning and land use in Louisiana. I want to move on to a review of the Kuntz case and talking about exactions. Many of you are familiar with exactions. We know that local land use has a profound impact on the environment, on a host of sociological factors impacting communities, and that communities increasingly are desiring to account for those externalities and the cost associated with those externalities through increasing research and and technical information, tying those costs to developers so that they are internalizing the cost of development as opposed to those costs being borne unnecessarily by the community. And so exactions are a regulatory tool used by local governments to require that the owner meet certain conditions in order to secure necessary entitlements. This has long been considered a valuable tool for promoting economic development and again allowing developers to internalize those costs as opposed to having them externalized and borne by the community. But obviously, hanging over all of this is our constitutional protections, right? Specifically, the Fifth Amendment. And we know that the Fifth Amendment says in its final part, nor shall private property be taken for public use without just compensation. And so as you can see, there is an issue about at what point does a community's exactions or a pursuit of exactions constitute an uncompensated taking in violation of the Fifth Amendment. And so this is the central issue that the court has dealt with in zoning cases. And up until 2013, many felt that this issue was resolved. Just to review our history of zoning cases, or should I say a selected history of zoning cases. We began in Penn Central. That is the case those of you from law school will recall, dealing with the historic preservation ordinances with Penn Central Station in New York. The court there found that a range of factors could be considered when substantive restrictions were limiting property rights otherwise held in property owners. In this case, it was the right to build above the station a skyscraper that was not in step with the historic preservation guidelines and a controversial architectural move in the city of New York. The court concluded there that the factors to consider when weighing those regulations against the rights of private landowners included the economic impact of the regulation on the claimant, particularly the extent to which the regulation interferes with distinct investment-backed expectations, and the character of the government's action. So here, the court allowed the historic preservation regime in New York to continue, even though it limited the ability of this investment group, which, as you may recall, had purchased the station with the goal of building the skyscraper above it. They were allowed transferable development rights to use the air rights somewhere else for a similar construction, but not on this property, and the court upheld the locality's discretion in doing so. 10 years, almost 10 years later, in Nolan v. California Coastal Commission, the court took a more conservative approach, and we have an opinion authored by Justice Scalia here, which pulls back some on the court's guidance in Penn Central. You may recall the Nolan family wanted to exercise their option to purchase shorefront property that they had leased for years. In order to exercise their option to purchase the property, they had to tear down an existing bungalow structure and replace it. That project required the approval of the California Coastal Commission. And upon reviewing the application, the Coastal Commission granted a permit subject to the Nolan's recordation of a deed restriction, which would have allowed a public pathway along the ocean line of the property. The Nolans contested this outcome, and eventually the case landed in front of the Supreme Court. And while the court recognized that a broad range of governmental purposes and regulations qualified as legitimate state interests, that did not, and thus did not constitute a taking, Justice Scalia reasoned that the constitutional propriety of the Coastal Commission's actions depended upon the existence of an essential nexus between the Nolan's construction project and the Coastal Commission's easement requirement. And so here the court establishes this essential nexus test. Now this is the first prong of a test that the court continues to evolve. Excuse me, I'm going. Okay, it didn't go. So the next case that the court in which the court refines the standard is Dolan v. City of Tigard. And there, the Dolans proposed redeveloping land that was in a 100-year floodplain and therefore subject to restrictions under the local government's comprehensive zoning scheme. The Dolans applied to the City Planning Commission for the necessary permits. The zoning scheme, consistent with the zoning scheme, they approved the permit subject to Dolan improving a storm drainage system within the 100-year floodplain and dedicating a portion of it to the city's greenway and dedicating an adjacent strip of land for a pedestrian and bicycle pathway. The court here strikes this down and adding onto the essential nexus test, the court goes further and adopts a rough proportionality test. Under this test, and there's no mathematical precision required, but the city must make some sort of individualized determination that the required dedication is related both in nature and extent to the impact of the proposed development. So where we leave off from Dolan v. City of Tigard is this essential nexus and rough proportionality test for determining how cities can pursue exactions, right? Negotiations with developers, requirements for the release of entitlements to move forward with the development of land. And the court establishes that there's Justice O'Connor, as I point out here, references that in Lingle v. Chevron in 2005. Many scholars argue that the court did not have a cohesive jurisprudence with regards to takings cases and exactions in particular. And so Justice O'Connor attempts to articulate something coherent in Lingle. But we don't see this really addressed again until we get to the 2005 case of Kuntz be the St. John's Water Management District. This is Mr. Kuntz, and as you probably deduced, and let's talk a little bit about the background of this case. This is the last zoning case the court has taken up. It is a controversial case among scholars and professionals. Many of you, I'm sure, are familiar with this, although it does not receive the kind of popular recognition that maybe the Kelo case does, right? Everyone knows Kelo. Everyone knows that they took Miss Kelo's house, and everybody's upset about that, even though many scholars, including myself, think it's a relatively non-event in the law and an affirmation of several decades of precedent. However, that case has cultural relevance that Kuntz didn't have. Mr. Kuntz purchased property in 1972 near a highway in Orlando. The state of Florida classified a large portion of that land as wetlands, and therefore, as we're all familiar in Louisiana, Mr. Kuntz was required to obtain a development permit from the St. John's Water Management District under a state act which had jurisdiction over the property. And that state act required that landowners provide reasonable assurance that proposed construction on wetlands is not contrary to the public interest. And so the landowner also must select a form of mitigation that offsets the adverse effects of the development. Mr. Kuntz applied for a development permit in 1994. He offered as his mitigation plan to place 11 acres of the land in a conservation easement. The St. John's Water District found this proposal inadequate and suggested their own alternatives, such as increasing the size of the conservation easement while decreasing the size of the development or proceeding with the development plan and paying to restore wetlands on district-owned land elsewhere. The district stated that it would favorably consider alternatives presented by Mr. Kuntz, but Mr. Kuntz was dissatisfied with the options before him, and he refused to negotiate with the district, and they denied the application. Kuntz filed suit in state court, claiming he was entitled to money damages due to the district's unreasonable exercise of the police power, constituting a taking without just compensation. The Florida court found that Kuntz had not exhausted all of his administrative remedies and granted the district's motion to dismiss. The Florida District Court of Appeal for the Fifth Circuit reversed. On remand, the Florida Circuit Court found that the district's actions constituted a taking under the Nolan-Dolan test. Thereafter, a Florida District Court affirmed, but the Florida Supreme Court reversed, distinguishing Nolan and Dolan. And they distinguished it on the grounds that the District Court denied the permit rather than granting it subject to a condition, as the courts in Nolan and Dolan had done. In addition, the court addressed whether a demand for money rather than real property could constitute a taking under the Nolan-Dolan test and concluded that it could not. And the Supreme Court, acknowledging a divide among the lower courts, granted cert to revolve the issue. So what's at stake in Kuntz? First, whether a permit denial was subject to the Nolan-Dolan test. And second, whether a demand for money could constitute a taking requiring just compensation. Notably, as you know, Supreme Court cases come and go, and various parties file amicus curiae briefs. Notably in this case, the United States Solicitor General's office elected to file an amicus brief in support of the district. Their interest in the outcome related specifically to the power of the federal government to regulate wetlands under the Clean Water Act. They viewed this power as parallel to the power of the state of Florida to regulate wetlands and land use under its state statutes. And the Solicitor General indicated that the United States has a substantial interest in the sound development of the relevant constitutional analysis in cases that may affect its ability to implement the Clean Water Act consistent with constitutional protections. So a lot at stake here from the view of the litigants at the outset of this case, particularly in view of the exceptional case of the Solicitor General weighing in on a case. Some felt that the constitutionality of the Clean Water Act, at least those provisions relating to the regulation of wetlands, was in danger. As we have reviewed, prior to this case, courts did not subject the denial of land use permits or the imposition of monetary conditions to heightened scrutiny under its previous decisions in Nolan and Dolan. And so we have the essential nexus and the rough proportionality test that we've established here. But the courts had pretty much stayed out of the range of negotiations that I know all of you are familiar with that go on in everyday land use across the country in various local governments and states. We understand that we have a system of negotiation where the site planning process, which is the first step for many people in jurisdictions, begins a conversation with the city and indeed many other interest groups in a community where developers are often willing to offer concessions or to revise development plans in favor of the government's concerns about the impacts of those of the development plan or the community's concerns, and that has been kind of par for the course for quite some time. Mr. Kuntz's protest here and the court taking this up raises an interesting question, right, that was scary for local governments. And on the previous slide, you read that local governments were very concerned about constraints being placed on their ability to engage in this kind of negotiation, specifically because the extent to which they are able to, through the police power, express the desires of the community and its welfare and its health and well-being, but also the ability to externalize costs to developers, which is a large function of the exactions that occur routinely in development. So in Kuntz, the court holds that under the unconstitutional conditions doctrine, which prevents governments from coercing people to give up constitutional rights, the courts cannot distinguish between approving a permit on a condition and denying a permit because the applicant refused to agree to a concession. And so the federal Constitution can be violated in permit denial cases, not because the property interests were taken, but because extortionate demands burden the right to have property taken without just compensation. And so many scholars took issue with the court's kind of strong language in characterizing the negotiations that often occur at the local level with regards to various developments. I know I have represented clients, I'm sure many of you, who do feel like this is extortion, who do feel like governments are exercising a heavy hand, and because they do not desire to pursue constitutional litigation as Mr. Kuntz did, they want to get their building built, they may not protest in this manner, they may not raise these questions, and so this regime has continued. The court weighing in the Kuntz case presents a number of issues. To look at the opinion, the court addressed whether or not a permit denial could be subject to the Nolan-Dolan test. The court explained that these extortionate demands from local government owners frustrate landowners' rights under the Fifth Amendment and therefore constitute unconstitutional conditions. The court was particularly concerned about local governments attempting to evade the Nolan-Dolan test via language in reasoning that granting a permit and a condition with a condition attached is no different than withholding a permit until a certain condition is met. Unsurprisingly, this was a split decision, almost a 5-4 decision with a conservative-liberal split. Justices Roberts, Scalia, Kennedy, Thomas, and Alito joining in the majority opinion, Justices Ginsburg, Breyer, Sotomayor, and Kagan joining in the dissenting opinion. And Justice Kagan's dissenting opinion incorporates many of the concerns and arguments that local governments were making with regards to this case. Justice Kagan agreed that the Nolan-Dolan test would apply if a local government made a demand such as the ones that we've established in the previous case law, but she failed to see how the district in this case, the St. John's Water District, had actually made those demands. And she states that they never demanded money in exchange for the permit. Second, she concedes that Kuntz may be entitled to recover money damages under state law. She disagreed that a taking had actually occurred in this case. And so there we have her disagreeing that this negotiation that produced these conditions actually constituted a taking. The implications of Kuntz, I think many would say are still a little unclear. Before Kuntz, all but title exactions were subject to a judicial presumption of validity. the burden imposed upon the applicant to prove the denials or monetary exactions were unreasonable, arbitrary, or capricious. Post-Kuntz, denials of permits where applicants failed to properly mitigate project impacts are now subject to higher scrutiny, a judicial standard that requires the government prove its actions meet the Nolan-Dolan standard. And so this is what many local governments and in the planning and others in the planning community are concerned about, and we'll see going forward what the implications of that are. We are at about 2:20 almost, and I think we have about 20 minutes left, so I do want to move on to get to our discussion of short-term rentals. But Kuntz, many argues, represents a continuing trend towards strengthening private property rights in the courts. It creates confusion, but it does not explicitly prevent local governments from negotiating in the permit application process. So we continue to see how that plays itself out. Who here has used Airbnb? Vacation VRBO. I haven't used that one. You've used VRBO. Actually, I think my wife used VRBO for our last vacation, so maybe we have used that as well. The sharing economy, right? How does the sharing economy intersect land use? So there's a ton of exciting things going on in this area. Very interesting questions about land use and mobility with the projected advent of autonomous vehicles and how that will impact how we move about cities and how we plan and zone land. Those are exciting questions. You could do an entire presentation on mobility and the sharing economy. But more present and more immediate are concerns about short-term rentals and how those intersect with existing zoning regimes that restrict your ability to rent property on a less than 30-day basis, less than 60-day basis in some areas, and all of the regulatory issues that stem from these sites, which basically are intermediaries for persons. If some of you rent out your house on Airbnb, someone did. Are you in New Orleans or are you here? Okay. Obviously, this is something that New Orleans is dealing with, updated its zoning regime in 2014 to address this, including the establishment of a registry requirement. But as we're finding in New York, and in San Francisco and countless other communities around the country that are scurrying to address the new sharing economy and the opportunities that these platforms present. Compliance and enforcement is a huge issue. And many laws are designed to put that burden on these companies, and they, as we will find, are pushing back. Just a little background here. We're looking at a valuation now with a recent investment from Google Capital into Airbnb that gives it a $30 billion valuation, more than the companies, the leading hotel providers in the world. And so, again, this is a company that started in 2008. We know that all of these hotel groups have been around much longer than 2008. And so, good time to, if you invested in Airbnb earlier, if you knew somebody, you probably wouldn't be sitting in this audience today, right? But 70% growth rates. This is not going away. And the implications it has for the economy, and particularly how we regulate who can live where and who can rent where and for how long, are many and growing exponentially with each passing day as communities more and more wrestle with this. The lack of existing regulation of vacation rentals and transient accommodations is becoming one of the biggest zoning issues. There's an explosion of litigation, and so we see this on the horizon. Existing short-term rental restrictions can generally be divided into 6 types, which I have listed here. Full prohibitions and geographically based restrictions involve those localities that fully prohibit short-term rentals, and they do so on a community-wide basis. Some municipalities also enact full prohibitions only in certain geographical locations, such as particular zoning districts or particular neighborhoods. Quantitative restrictions, there are municipalities that have enacted certain quantitative restrictions that allow short-term rentals throughout the community, but limit the number of such rentals. And they take the approach of issuing short-term rental permits to property owners, but cap the number of permits that are available. Proximity restrictions, in contrast to quantitative restrictions, certain municipalities restrict short-term rentals from being located within a certain distance from an existing short-term rental property, so that we don't have a concentration in certain neighborhoods, and that we can more evenly distribute this. Obviously, if a neighborhood feels as if they are being overburdened by short-term rentals, and that is having a measurable impact on neighborhood character, or more importantly, property values, then these types of restrictions seek a middle ground, right, by still allowing these vacation rentals to continue, but decentralizing them and distributing them more evenly throughout the community. Operational restrictions, these are designed to prevent new entrants into the short-term rental market. A municipality may limit the maximum overnight occupancy of a short-term rental property. And then there are licensing requirements affecting short-term rentals, and some local governments require that property owners seeking to use their properties in this way obtain a license to do so. And so a few years ago, the New York Attorney General found Airbnb to be in violation of the city's, New York City's illegal hotel law, demanded information on the operations. Airbnb refused to cooperate, and I have a quote here from the CEO at the time: "There are laws for people and there are laws for businesses, but we're in a new category, a third category, people as businesses, and as hosts, you are micro-entrepreneurs, and there are no laws written for micro-entrepreneurs." Obviously, lawmakers disagreed with that, but it certainly captures the spirit of entrepreneurialism, and the feeling among companies venturing into this space, and also property owners who have property that they desire to lease in this manner, that this is a new terrain and may be beyond the reach of existing law or governmental oversight. And so that is Airbnb in the beginning. But obviously the state has kind of caught up to things, and so New York Governor Cuomo has signed legislation that imposes fines on hosts who advertise illegal short-term rentals, and this is part of a larger regime which now regulates short-term rentals through a registry which you are required to register your property with. But here, we have fines and penalties imposed. Airbnb filed a lawsuit in the Southern District of New York, and that case is underway right now. But this is a growing trend, and cities have three what many call bad options. Number one, invest in heavily enforcing short-term rental laws. which is very costly. We're in a period of municipal fiscal difficulty, if you will, in many cases insolvency. We've seen a run-up in municipal bankruptcies. We know that there are declining sources of support from the federal government and the state government for localities at a time when the public's appetite for new taxation has effectively bottomed out. And so getting the wherewithal to enforce a regime to regulate all of this is probably low on the priority list of many municipalities as they face aging infrastructure and all types of other more pressing concerns. Decide not to regulate, right? Let the market work here. Obviously, there are interest groups in all cities. Think hotel owners, think neighborhood groups who are concerned that these types of pursuits will erode neighborhood quality and property values, or very, tangible concerns about, a transient flow of people coming in and out of the neighborhood that might lead to crime, that might lead to other undesirable activity. There are real concerns that people have if a city doesn't regulate. And then revise land use style regulations to make them more enforceable. And we'll look at San Francisco, which chose the third option. So San Francisco enacts an ordinance to allow STRs on certain terms. You have to register with the city. You have to obtain a business license and pay the city's transient occupancy taxes. You have to agree on a 90-day limit on unhosted rentals and comply with other city rules and regulations. If you all know anything about the San Francisco property market, I was just at a conference with a colleague who lives in that area who explained to me that renting out, and this was an accessory unit, so not exactly the same thing that we're talking about with short-term units, and this was a conversation on the regulation of accessory units, but she had to rent out an accessory unit just to stay in place. Right, just to be able to afford the uptick in property taxes and other fees that are happening in the most expensive, one of the most expensive property markets in the country. So this is not just about, hey, I'm gonna, rent my place out for the weekend because I live on a parade route, right? And that's how we may view it down here. But in many property markets where the cost of housing has far outstripped the ability of residents, and we're not just talking affordable housing. We're talking about people like all of us who work every day who still are not able to afford a house in somewhere like San Francisco where average home prices are approaching $1 million, or other major metropolitan areas where people who otherwise would be considered middle or upper middle income in most of the rest of the country, certainly places like Baton Rouge, are finding it very difficult to stay in their homes. Short-term rentals give them an option, right, to be innovative and to find new revenue streams to sustain their lifestyle or, more importantly, just stay in place. And so hosting platforms are required to provide notice to STR users regarding the rental laws, right? So we're not just regulating those who seek to rent out their property, but we're also attempting to regulate the hosting platforms. They also have to comply with the city's business tax code and transient occupancy taxes, maintain records, and there are civil and criminal penalties that attach to violators. This slide is a bit of a duplicate. But new changes came in 2016, this past summer, because they were having a problem with enforcement and verification. And so the ordinance continues to evolve, in real time, attempting to maintain pace with the ever-increasing flow of individuals who participate in these platforms. Airbnb and HomeAway recently brought suit alleging violations of federal law, of constitutional claims with regards to the First Amendment and the Dormant Commerce Clause. And so this is now underway with big litigation both in New York and in San Francisco. We'll likely see this continuing going forward. In San Francisco, as I mentioned, it has revised, amended the ordinance, but reiterated the need for enforcement with 75% of STRs not abiding by the law, and a study that Airbnb alone had taken 2,000 units of housing off the market in the city. And so there are a wave of unexpected consequences and impacts from the short-term rental market. Indeed, those who are no longer looking for traditional rental arrangements, but are looking to either string together short-term rental arrangements. If you're a transient worker and you want to be close to work and you have transportation issues, maybe you string that together. A host of things are happening in these markets which appear to be beyond the ambit of local and state regulation. And so certainly we want to watch this space as we expect the litigation and the policy innovation on the ground, right, to continue to grow as communities, not just in the San Franciscos and the New Yorks, right, but also here locally attempt to resolve these issues. Two very recent, relatively recent case examples that I pulled. You do a search for short-term rentals. In the last 2 years, there's just an explosion of case law around the country. And so just pulling two, one here in Pennsylvania, we have a homeowner who used the property temporarily for vacation rentals, cited for violating a zoning code when single-family dwelling definition did not prohibit the activity. But the zoning board concluded that the use constituted a lodge under the zoning regime's transient dwelling, a lodge and a transient dwelling accommodation under the local zoning regime. The trial court found in favor of the zoning board and the appellate court reversed, rejecting that this lodge classification applied in this case because the homeowner lived there most of the time, right? So here we have in many zoning regimes regulations for accessory uses, right? If you want to rent out a space above your garage, right? We know how to deal with that, and we have ample examples for how to regulate that. But if you are willing to rent a bedroom to a stranger for a weekend, every weekend, because you live in that kind of a market and you can make a lot of money, it's not as clear as to how to deal with that. And because, as we covered at the beginning, zoning is such a local affair, right? We have to look to the idiosyncrasies of local zoning ordinances, and in this case and in the next case, the definitional issues in those ordinances, which may not have been tested in the way that short-term rentals are now testing them. Another case dealing with a homeowner who purchased a home and began a short-term rental. The county issued an injunction arguing that the zoning ordinance, the owner argued that the zoning ordinance didn't expressly prohibit short-term rentals. The owner appealed a summary judgment, and the appellate court affirmed, holding that the zoning ordinance definition of transient lodging effectively rendered the short-term rental an unpermitted use. So there the court found in the definitions of the zoning ordinance an established classification for transient lodging that was being regulated. And even though the homeowner argued that there wasn't specific guidance in the regime as to how to handle these short-term rentals, the court there was able to, by analogy, reach the conduct and prohibit it without any kind of substantial modification to the zoning regime. But we have any number of cases where a whole host of issues are popping up. So I don't follow this closely, but in just my investigation here, there is just a potential flood of litigation at the local level as communities grapple with existing regulations, and to the extent that existing regulations do not adequately address the concerns that short-term rentals raise, it is a difficult environment politically, right, to modify those regimes to address it in a way that may protect entrenched interests or reflect a more conservative take on what the reach of short-term rentals should be going forward. And the politics of that are that this, for many people, is an emerging revenue stream, and one that will likely continue to grow. And if anything that San Francisco and New York shows us is that even if we are able to politically jump the hurdle of passing new regulations and modifying existing zoning regimes, that the enforcement issue, because of the sheer scale to which this is occurring, almost renders some of those regimes meaningless, as it's just simply too hard to track and catch up with all of those. So that's my presentation. Again, I wanted to give you some update on the Coons case for those of you who weren't familiar, even though it's now 3 years old and a little bit established, but still the latest big zoning issue that we have. And the more exciting yet still fast-moving and evolving issue of the impacts that the sharing economy continues to have on issues of land use and zoning and planning regulation. So if there are no questions, or if there are any questions, I'd be happy to take those now. Well, I can still see your eyes, so you're still somewhat awake. And so I'm happy that I didn't put you to sleep with this. I really appreciate your time, and certainly appreciate CPEX and Jones Walker for hosting this and having me. I will be back with you at a later forum, which, oh, I'm closing up and we have questions. Yes? I'm not, and certainly anyone else can weigh in. I know that there are some ongoing issues in New Orleans that are being addressed. I'm not familiar with anything on the plate right now in Baton Rouge addressing this. If there are any issues, if there's any ordinance here or any conversations in Baton Rouge to address the Airbnb issue. And obviously, I think this is an issue in New Orleans because New Orleans is obviously a tourist magnet and somewhere where many people don't mind, particularly around the conventions or the festivals, sharing property. I think that local real estate dynamics and demand issues have some impact on where this issue arises, but I think it's coming for everywhere. Yes? Some chatter online, yes. So officially, I am not aware of anything happening here. And I don't know if anyone else, some of you, if it was happening, wouldn't know. So, I'm looking at you over there. So no, not aware of that. So again, this is an exciting area. I think if I was doing this in 2 years, I'm almost certain I'd be talking about mobility and the desire of communities to revise land use guidelines based upon autonomous vehicles and automation in vehicle transport. If you're interested in that, see me, because the scholarship on it is just fascinating if you really get into the kind of future stuff. But much of this technology is on the way, and it raises fascinating questions about how we zone and regulate land, much of which is based off of early and middle 20th century technology and conventions around family, the family and work relationship, right? And so, mobility, electricity in the late 19th century allowed cities to really grow because it enables streetcars, it enables this technology that brings a number of advances to city living. Many are arguing that automation in mobility, and not just self-driving cars, but bicycle sharing, Uber. Who here is taking an Uber? We all, I get to DC now. I used to live in DC. I know the metro system. I'm less and less on the metro, and I'm more and more in an Uber. So these changes are coming, and how we think about parking requirements, right? How we think about neighborhood walkability, how we think about density, which is completely, much of the scholarship on density is all about sociological determinations about who should live as close to whom and how many concentrations of people do we want in a certain space. All of that gets turned on its head, and I think that's an emerging area that we'll see a lot of exciting innovation from in very shortly in the years to come. I think I'm up against the limits of the time that has been given me. Any other questions? Thank you so much again. Thank you, CPEX. Thank you, Jones Walker. And you all have a good day.